come and talk to you all about these courses which we introduced from this academic year, as you all know. There used to be LLB, started way back in 1979, and then LLM later on. So for the first LLB batch students, perhaps I don't know, some of you might know, one of the students of the first batch became the Chief Justice of India, our first batch student. And then another student also became a Supreme Court judge. Two of the High Court judges and AP High Court judges were our students. So there are many in judiciary, as senior lawyers, and in different positions in this country. And I also wish that some of you might one day become Chief Justice of India. I wish that it's not impossible. It is proof that it is possible. If you have the determination to study law and to follow the career in law, it's not difficult for you to become a High Court judge or a Supreme Court judge. One actually normally becomes High Court judge first, although there is a provision in the Constitution to make a very senior advocate as a Supreme Court judge directly. Most of them go through High Court judges. If you start practice in High Court, and after 10 years, you will acquire the requisite qualification to become a High Court judge. And then after High Court judge, Chief Justice, etc., and then the route is clear. So I wish that most of you could occupy positions of high eminence in the judiciary as well as in the practice of law. It's not only judges, even as lawyers. There are many lawyers who are very famous as lawyers. A famous lawyer, if he is asked to take up judgeship, he will say, I'm sorry. I only tell you an example. When the income tax raided one advocate in Delhi, maybe about 6 months back, and they found about 5 crores money in his house. He said, what 5 crores? I earn 20 crores a year. That's my earning. So 5 crores in my house is not a big job. My earning every year is about 20 crores. So any standard Supreme Court lawyer, I'm not talking about Supreme Court judges, Supreme Court lawyer earns a minimum of 1 crore. They charge 10 lakhs, 20 lakhs, like that for every person. And then the cases of big industries, etc. So what I'm trying to emphasize is that you have a very bright future, you have a bright career, and you have also chosen the right institution. Because this institution, as I told you, is known for its sincerity and known for its eminence. Many of our former students are gone and occupied very high positions. As she was telling you, after closing the LLB, again there was a demand rather from the alumni, many of them senior advocates working in different places, that we should revive the legal education in Rangaiah University by starting these 5 years law courses on self-financing basis or at least. Accordingly, we requested the university administration to start a law course. And then when I was in the US, actually at that time, I don't know, they appointed me as chairman board of studies of this law. And I did all the spade work that's necessary from there itself. And then we secured the approval of the Bar Council of India for both this BA LLB honors and BBA LLB honors courses. And only after securing as per the Bar Council of India regulations, law being a professional course, the legal education is regulated by Bar Council of India, a professional body consisting of only advocates. And without the prior approval of Bar Council of India, nobody can start a law college and impart legal education. So we secured the approval of the Bar Council of India for both these courses. And since this is the first year, maybe although 60 is the maximum capacity. We could secure only about 26, 24, I don't know, some more are likely to join, that's what they say. So now coming to the courses, rather, I don't know. Main degree that you are going to be awarded after successful completion of 5 years of this integrated double degree program. This is called integrated double degree program. This is how we indicate the nomenclature of the degree: BA, LLB. This is the degree that those who are joined in BA, LLB honors course will be awarded on successful completion of the 5 years. And another one, BBA, LLB honors. Bachelor of Business Administration, Bachelor of Arts. You have other programs also available as approved by the Bar Council, BSc, LLB, BCom, LLB, etc. But we prefer to have these two, particularly in almost all the national law schools. You have BA LLB programs, BA LLB or BA LLB honors programs, because when the 5-year course was started way back in 1980s, it was actually on the basis of the recommendation of the Hidayatullah Committee. Justice Hidayatullah was one of the Chief Justices, Chief Justice, and he recommended that instead of three years can continue, but at the same time, they also recommended that there can be an integrated double degree program and giving admission immediately after 10+2, so that they thought only those who are really interested in legal education or those who are really interested in legal profession will join, because after 3 years degree, normally people who have nothing else to do, people who are employed already, people who are doing some job, they take up this for the sake of legal knowledge, general legal knowledge, as well as for the sake of getting some promotion in their jobs, etc., etc. But they are not serious legal professionals. So if one wants to take up serious legal profession, they thought it is better to catch them young, when you are just about 18 years old or 17 years old, some of you may be just 17, 18, so that we can impart the seriousness of the legal education, and most of those who are joining the 5-year course would definitely be very serious in the legal profession. That was the expectation, and accordingly, now we have both the 3 years and 5 years programs continuing. And we, again, on the recommendation of the alumni, we thought of introducing this BA, LLB, BBA, LLB honors programs. Now, what is this? Just for your general knowledge purpose. BA is okay, Bachelor of Arts, Bachelor of Business Administration. And this LLB, why is LLB? Earlier days, we used to call it Bachelor of Law, BA. I think in Andhra University, till very recently, the degree that was awarded was BL and ML. Yeah, Bachelor of Law and Master. But then why this BL became LLB? And what is the significance of these two L's?
Legislative law of bachelors. Legislative law of bachelors. Legislative law of bachelors.
Legislative law.
Legum bachelor is a Latin term.
Yeah, that's the Latin term. So you have been using Google very nicely, I know. Google has been giving you these replies. If you go to Google and say LLB, what is the significance of LLB? They say legislation in Britain, actually, earlier they used to call it Bachelor of Laws, plain. But later they changed it. There is a history of law in Britain. Earlier, the judges used to make law, which we call it as common law. And in the continent, rather than Britain, there used to be codified law, common law and codified law. The distinction used to be there, but afterwards again, in Britain also, British Parliament became active and they started making law. Legislative means legislature. When legislature makes law in political science, legislature means members who are elected by the people to represent them. People's representatives. We call it assembly here at the state level. We call it parliament at the national level. In America, they call it Congress, Senate as well as House of Representatives, etc. Whatever may be, in Britain they call it Parliament. So whatever may be the name given to that body, it is the legislature is the general term used in political science, which represents the law-making body. The body that makes law is legislature. As you all know, perhaps, the state or the government. State has different connotation, but come to government, we say there are three different branches. That is legislature, executive, and judiciary. So legislature makes law, executive implements it, executes it, and then in case of any dispute, because legislation is drafted in what? After all, language. Language consists of words, and most of the words have different meanings. So it becomes necessary sometimes to interpret, means to give a technical meaning to any particular word or a sentence, and in such cases, the courts or the judiciary, they try to elicit the intention of the legislature, because once it is legislated, then it doesn't go back to legislature to say what it is. What does it mean? What do they actually mean? Why did they make such law? Law consists of various sections, sentences. Each sentence has some words. Words have different meanings, sometimes ambiguity meaning different. That is what is done by the advocates. The advocates argue before the courts that this is the language used and this language has so much meaning. And therefore this should be interpreted in a particular way. Interpretation of law. Perhaps you will get a paper after a second or third year along with jurisprudence, the subject of interpretation of law, principles of interpretation, not rules for interpretation of law. Now, so that is the legislative law, but we are now going to study not merely legislative laws, but we are also going to study something very general, in general laws. That is why another interpretation given for L is, one L is the law, and another L is a law, and plural, Bachelor of Law and Laws. Bachelor of the Law, a law, or laws. In plural, there are many laws in this country, starting from the highest law of the land, the constitutional law, which is supreme. We call it supreme because all other laws, whether made by parliament or state legislature, have to be in conformity with the constitution. If they are contrary to any provisions of the constitution, those laws will be declared by courts as unconstitutional. That's why supreme law, Granda we call it, supreme law or highest law of the land. And there are other laws, commercial laws, family laws, mercantile laws, labor laws, etc., etc. So, these are a law, the law, the meaning of the law, study of the law in general. Law in law, the law. What is the law? What is the meaning of this term law? How should we understand the term law? What is its purpose? Why laws are made? Are there any principles to which these laws should conform? And law is not the only term reserved for our laws, but there can be other types of laws. Newton's laws of motion, you might have studied as students of physics. They also call it law. The three principles are rule, he called it laws. So, moral law, sometimes people call as moral laws. Every game has its own laws, rules, or whatever, some people say rules. So, how we distinguish our law from the other law? That means, what are the characteristics of law in order to qualify as a law? The state law, whatever you may call it. So, this is what is law, why law, where does it function, how does it function, and various types of interpretations have been given to the word law while explaining. Some people explain it from the point of view of God, laws of God. Every law has to be, he has to confirm the laws of God. God has made so many laws, and after all, we are all creatures of God. Or laws of nature, or laws of morals. Laws, every legal principle should necessarily comply with the moral principles. What morals, of course, we don't talk about. So that way, we should distinguish the law that we are concerned with the other laws that are prevalent. So, what are the basic characteristics of law? Why law is needed in a society? Is it needed in fact? Can we not live without law in this country or in any country? Is it possible? Can you think of any society where the law doesn't exist at all? Not in the ancient times when even the state was not there, even local self-governments were not in existence. Perhaps the ancient Marx called it ancient communism. There was no state, there was no administration, there was nobody, people used to live just like that. There was no order in the society, etc., etc. But a time came in the history of Homo sapiens that they thought it better that we should have some regulation in a society so that everyone can enjoy their lives as human beings. Every human being has certain basic rights. Like he should not, another person should not come and touch you or do anything with you by force. The basic rule. So for an orderly and peaceful society, perhaps, I'm not saying exact definitely, law is needed. It is at present, at the stage of the present civilization of the whole society in the world, law is an absolute. Without law, there will be anarchy. We say anarchy. People can do whatever they want. There will be no protection, there will be no security for the people, there is no security for your properties, there is no security for your person. Anybody can come, whoever, jungle laws, we call it. What is happening in jungle? Whoever has more power, might is right. A tiger can go and kill any animal, nobody to object. But should we have such a society? We are human beings. We are more civilized. We have brains to think. So, a stage came where people thought that there must be some regulation of the conduct and the behavior of the people so that all can live peacefully in an orderly manner, in an orderly society. And from that time onwards, whoever was the ruler, whether it was the slave society, the slave owners, etc., the kings, and then came feudalism, and then came kings, and now we have most of the countries or democratic countries where people, the voters are elected. Whatever it may be. Law and state are now considered at the present stage of civilization as absolutely necessary. But then, great people like Karl Marx, I think some of you might have heard his name. He was the proponent of the communist theory, communism, which was put in practice in Russia, China, and some other countries, Cuba, etc., and some other South Asian countries. Karl Marx, Marxist, we call them Marxists. And even Mahatma Gandhi. They prophesied a society in future where there will be no requirement of law and state. And Marx called that the law and state will wither away. Why should you be regulated? Don't you know, as a citizen, don't you know what are your duties as a citizen? When we are all highly civilized, the highest stage of civilization, everybody in the society has the capacity to understand what is good and bad for the society, and he accordingly behaves. He doesn't interfere with the other's rights, and he behaves in such a way that the others can enjoy their rights. No need for regulation, no need for law, but always, what is law? It always interferes with your liberty. It tells you what to do, what you did not do, what you should not do, what you can do, what you cannot do. Don't do this, do this. This is what the law does. So by doing that, it is restricting the liberty of the people. But still, that's good that the liberty of some of the people should be restricted. Okay, whether it is because of fear or whatever it may be, people don't come inside. So, a highest stage of civilization is prophesied by Marx and Gandhi, where they said there will be no need for state. There will be no, if there is no state, there is no law. There is no police. No state means no police, no legislature, no executive, no judiciary. People can live happily, peacefully. No regulation, no external regulation. I can regulate myself. We are all civilized to such an extent that we don't need someone else to come and tell me what I should do and what I should not do. Well, people called it utopia. Means we visualize something which might never happen. Utopia. Utopia, that means it's good. It's good if there is no state, it is good if there is no police, if there is good if there is no law. But then, what is the practical consequences of not having law, not having state, not having police? Because somebody said, state, a small joke like, father is taking his 12-year-old son in Dharmapeetam from Sankaravanas. He is walking this side from Mitru. And then this fellow studied somewhere something in books, state. So he asked his father, Daddy, tell me what is state? Show me where is state. The father is a real problem. Where he said, how to show him the state? He is asking me where is the state and show me the state. State, does it exist? It exists in your mind. It's an idea. But whom can you show when you say this is the state? And he thought out carefully, and then as he was walking down, he saw that another bed police station. And said, yes, good. Babu, this is state. He showed the police station to him and said, this is the state. Because law most of the times tries to regulate your conduct through this institution of police, whose duty it is to maintain peace and order in society. Okay. So, law, the general law in general, we study all these things. What is law, why law is required in society, etc. What is its purpose, how to distinguish law from other laws like natural laws, etc., etc. And there are some very important legal concepts which we use in the study of law, like, for example, right, duty, property, ownership, possession, liability, intention, negligence, etc., etc. Corporate personality, person, what is a person? When we say a person, what is a person? A person is not only a human being in law. In fact, a person is a human being. But in law, even a company registered under the Companies Act, a trade union registered under the Trade Unions Act, the society registered under the Society Registration Act, they also acquire these legal personality. That means, like human beings, they too have legal rights. So, from this point of view, we study in general what is law, why law is required, what is, because various jurisprudence, we say jurisprudence, people who have tried to explain. Some people have explained, I said, from the point of view of God, morals, etc., what is law means. Some people said they have explained it from the point of view of history. Law consists of only the customs of the people. Historical explanation. Sociological explanation. People said law functions in a society. It is meant to bring order in the society. Therefore, you should approach the study of law from the sociological point of view, because it functions in society, it doesn't function in vacuum. Society consists of human beings. So they explain sociological, so you must always explain law either from the point of morals, either from the point of history, or from the point of sociology, and then Marx and others explain law from the point of economics. Economic explanation of law, right from the why we say law. During the period of slavery, maybe think about 1,000 years back, the law in most of the countries had supported the institution of slavery. Can we think today, can a law, because at that time slavery was legal. Slaves means they were not human beings. During the period of slaves were human beings, but not in law. They can be purchased, they can be sold. In the market, you own 100 slaves, you go and sell 50%, 50 slaves, or you go buy another 50 slaves. And the slaves have to work according to the orders given by the slave master. The slaves have no rights, etc. They can be beaten, they can be killed. That was the law. That means there was a stage where law perfectly protected the institution of slavery. Even during the days of, say, great prophets of religions like Jesus Christ and Muhammad, Prophet Muhammad, even during those days slavery was in existence, and they never opposed the institution of slavery because they thought slavery was absolutely necessary for society. Without slavery, production, agricultural production in those days was almost impossible, they thought. So they supported the institution of slavery. And then feudalism came, where human beings are considered as human beings, but there was forced labor. They have no right not to do work. They have to do work. Forced labor was the rule in feudalism. It's a development of slavery, because they are recognized as human beings. They can't be sold, you can't cause any harm to them, but still, you must work in the fields of the landlords. Forced labor. Then came capitalism. Feudalism has gone. And in capitalism, in strict theory, you are free. We have, for example, capitalism, you are free to work or not to work. Nobody can force you. You are free to do what work you want to do. Whether to do or not, whether to go and sleep in the house 24 hours, is up to you. If you want to go and sleep 24 hours, nobody can come and tell you, no, come and do this work, come and do that work. You are free. So to that extent, capitalism has been a development over feudalism. Then, why I am telling you all these developments is because law, right from the beginning, has been supporting those who are the property owners. Owners of property, slave owners. Law protected the slave owners. Law protected landlords who are owning thousands of acres of land. Now in capitalism, law protects the employers or the industrialists or the capitalists. Although you are free. So each development is a development in the sense of civilization. And therefore he says capitalism, next socialism, and then comes the highest stage of civilization is communism, where no state, no law exists. So this is again, let's not bother about that, but still, in theory, we don't go to that. Law is absolutely necessary. So the general study of law is part of it. That's why we say law. And the laws, plural, that means particular laws. There are criminal laws, there are commercial laws, there are patent laws, there are labor laws, there are constitutional laws, there are personal laws. So many types of, we make a classification of laws, various types of classification of laws. So a law means a law which is in force in this country today, whether made into law by parliament or not. For example, there is one law which we are going to study for maybe of arts, I will not for this semester or second semester, I don't know. It is not an enacted law, but merely a common law which we borrowed from the British common law, which is still no in this country, and it was not a legislative law in that sense. Study of legislative law, so study of law and laws. This law in general and the laws in particular. So that is what we explain. Another interpretation for LL, law and laws. So you are going to become an expert in the study of law in general, what law, why law, etc., etc. How it should be done. And the particular law, constitutional law, administrative law, commercial law, etc., etc. There are various laws. I think about 100 names have been given by the Bar Council of India, where you can choose from them for your options. Now coming back to this nomenclature again, we don't have now in our university anywhere this LLB, where I was the principal of KL College also, we started BBA LLB, not BBA LLB honors. So here we have started the honors course, which includes 8 more courses of studying law, either in one theme or in different themes or different strata. You can choose that when you come to your 4th and final year, 7th, 8th, and 7, 8, 9, 10. Those 4 semesters, 7th semester, 8th semester, 9th, 10th semesters. You can choose 2 subjects, 8 subjects more, 2 per each semester, and then only you will be eligible to get the BBA honors or BA LLB honors degree. Now this is about the degree, honors degree. Now what are the course structure? I'll just give you an idea about the whole course structure that you're going to, or program structure you're going to study in the coming 5 years, 10 semesters or whatever. See, the Bar Council of India, I've been referring to, this is a statutory body. Constituted statutory body means constituted under a statute, by a statute. There is, all of you, when you become advocates, your conduct as an advocate will be regulated by the act known as the Advocates Act. In India, you have what is known as the Advocates Act of 1961. So the Advocates Act provides for the establishment of the earlier Bar Council Act is there, but later on replaced by Advocates Act. It provides for the Bar Council of India not only to regulate the conduct of lawyers as professionals, as lawyers also you are bound by some code of conduct. There are principles of ethics which you have to follow, because people used to call earlier that legal profession, along with the professions like preacher or a teacher, was a noble profession. That is why even today a lawyer cannot advertise. You cannot give a big advertisement saying, all those who want divorces, please come to me. You can't give any such advertisement in a newspaper. Right? But I don't know whether that nobility still exists or not. Still, in olden days, along with teaching and preaching, that is religion, law, legal profession also was considered as a very noble profession because it is the lawyers who make sense for the lives of the people. People cannot live without basic rights, basic necessities, basic rights, and it is the lawyers who protect your rights. So that is why the legal profession was considered as a noble profession. Nowadays we say, well, in America it seems board career, expert at work here, do not proceed further. So these are the type of signboards you find when lawyers, in America, lawyers can advertise, but not in India at least so far. So this being a noble profession, there are certain norms, and to become a lawyer, you have to be graduated in law. Now it is first degree, second degree, integrated degree program, double degree, or whatever you call it. So once you get a law degree from a recognized university, you are entitled to practice in any court of law in this country, except in Supreme Court there is separate examination conducted, bar examination. If you pass that examination, then you can go to Supreme Court. Otherwise, any court in the country, you are entitled to go and practice. So, from that point of view, the Bar Council also has been given the additional responsibility of maintaining standards in legal education. In addition to regulating the conduct of advocates as a professionals, the Bar Council also has been entrusted with the responsibility of maintaining standards in legal education. So how the legal education should be imparted, what subjects have to be taught, how many years course it should be, etc., how a college should be established, how it should get the approval of the Bar Council, prior approval, etc. I told you in the beginning, we secured the prior approval of the Bar Council of India before starting these programs. So Bar Council of India, in addition to now broadly regulating the conduct of the professionals, also has the duty of maintaining standards in legal education. That's the Bar Council's duty. So accordingly they make Bar Council of India rules under the Advocates Act, rules of legal education. So every institution imparting legal training has to necessarily comply with these rules made by the Bar Council of India. Then only the law degree given to you will be recognized by the Bar Council. Because after completing the degree, if university gives you a degree, that's not the end. You have to again go and enroll yourself as an advocate. And now there is an examination actually. Unless you pass the examination which is going to be conducted by Bar Council of India, you will not be allowed to go and practice before the course. All India Bar examination, yeah. And that also we will train you in the final year. In addition to the normal papers trained, what is the syllabus for the All India Bar examination, etc. We will train you in the final year in the first and 9th and 10th semesters. That means we will prepare you for the All India Bar examination so that once you are outside the portals of this university, you can immediately go and take up the examination and get through that examination. Now, so as part of its duty, the Bar Council has prescribed a program structure which must be complied with by all the legal institutions or law colleges, and those courses are, let us not bother about the 3-year degree, that's a different matter. I am going to direct you about this double degree program. So in order to acquire your first degree, you have to study 12 courses. We use courses, subjects, papers, whatever maybe the nomenclature used, forget about it. 12 courses. In the first degree, arts or Bachelor of Business Administration, as the case may be. So 12 courses in all the 5 years. Normally we complete them by the 3rd year itself, so that the last 2 years will be reserved only for the law programs. So 12 courses, this is first degree. And coming to the LLB degree, the Bar Council prescribed that there should be 20 compulsory papers. One cannot think of becoming a lawyer without studying Indian Penal Code, without studying Criminal Procedure Code, without studying the Evidence Act, without studying the Constitution, without studying administrative law, without studying the law of contracts, so there are some basic papers or courses in law which must be studied. University has no freedom not to impart training in these courses, so they called it 20 compulsory law courses. They have given a list of what are those 20. Constitutional law 2, labor law 2, family law 2, constitutional law 2, something like that, personal laws 2, law of banking, etc., etc. And then they have given 4 clinical courses. We call it clinical because these 4 courses are expected to provide you the practical knowledge required to go and start practice in a court of law. Clinical. Understand, I think clinic, where the medical clinics, the hospitals where patients are admitted and medicines are administered. Clinical courses, professional ethics, which are very essential for you. And then drafting, pleading and conveyance. For initiating any action in any court, you have to first file some document, whether you call it a claim and reply, a written statement, or a petition, writ petition, or an appeal, or whatever it may be, counter, affidavit, etc. There are certain documents which have to be drafted by you as a lawyer. So, drafting, pleading, and conveyance. Conveyance means transfer of property from one person to the other person. Whether it is agricultural land or any other property, you write down a sale deed, a mortgage deed, etc., which are called, we call them as conveyance, gift deeds, sale deeds, mortgage deeds, exchange deeds, etc., conveyance. So, drafting, pleading, and conveyance is one such legal paper which we teach you only in final 2 semesters, final year. And then, after draft and pleading, professional ethics, as I said, and then alternate dispute resolution. Nowadays, this is acquiring a lot of importance because, you know, you will get lost if I tell you the total number of cases pending in all the courts in this country amount to almost 5 crores. What sort of legal system we have? What sort of judicial system we have? Cases are pending for more than 40, 50 years, some cases. And definitely, suppose I give an example of husband and wife. 25, 23, husband 25, wife 23. I mean, to give you an inkling or an example, an idea as to how the legal system or judicial system in this country is working. They married 1 year back. They said, enough is enough. So we'll take divorce. They filed for divorce. The district court or the family court grants divorce after how many years?
10 years.
I will take it 5. After 5 years. This is the minimum, oftentimes. Sometimes it will be 1,000, perhaps. It may be done in 6 months or 1 year, but otherwise,
Including the appeal. Including the appeal.
so, from district court, the party who loses in the family court goes to high court. The high court takes
10 years.
5 years, let us say, it goes before a single judge. The single judge decision is challenged again before a division bench. Another. And then you can go and challenge that decision in the Supreme Court of India. There you can be sure about at least 10 years. So total, by the time you get divorced, you are 60. fun of applying for divorce. At the age of 25, you apply thinking that if it comes within another 1 or 2 years, you can again marry and lead a happy married life. But the judicial system functions, the wheels of judiciary move so slowly. And court after court, appellate court after appellate court. Why can't they say, yes, well, okay, district family court, high court, that's finished, and enough. Why divorce petition should go to Supreme Court? Have they no other business to do in Supreme Court? There is a constitution. There are so many cases pending before the Supreme Court which are challenged under the Constitution of India. Cannot confine themselves to matters relating to the Constitution. Why even a petty criminal case and a petty family case should go up to the Supreme Court? There is something wrong with the system which has to be, and that is why I think yesterday, if you read it in the newspapers, today morning, yesterday the Supreme Court observed the 75 years of its existence. 28th of January 1950. Although the Constitution came into force on 26th, officially the Supreme Court started its proceedings on 28th January 1950, and therefore yesterday was the celebration of 75 years along with the Supreme Court judges, etc. Even the Prime Minister was there. And if heading, even if you see this to his papers, speedy justice. It has been a slogan for the last so many decades in this country. Speedy justice. What is speedy justice? I only gave the example because property matters sometimes perhaps may not cause you much damage. But even if your personal matters like divorce petition, if they take 20 years, 30 years in the courts, do you still believe that justice is being done by these courts? We call them courts of justice or courts of law? Courts of law, administering justice. I don't know. If this is the way things are going on. It's not that I'm trying to criticize you or I'm trying to rather tell you that, but there is something drastically wrong with the legal system and judicial system in this country. And I had to attend a rent control case in America. I think my son was allotted, so I went along with him to court to see how courts are functioning in America. Petition was filed 1 week before, and that day the court called, and then both the lawyers argued for half an hour each, and by 2 o'clock the judgment is given, and they said within the next 1 week it has to be implemented. That's all. If you go for a same rent control case in India, I am sure minimum of 20-25 years will be the time that will be taken by the courts to finally. So, I don't know why I went to that. Yeah, clinical papers. So, alternate dispute resolution. Now, this is the background in which now even the Supreme Court is insisting that instead of going to courts, you go for mediation, you go for arbitration. Arbitration, mediation, or the alternative methods of dispute resolution. There are also judges, there are also human beings. Instead of that, you go to a retired judge or a retired professor of law or somebody and then say, this is our problem. You explain one day, they will explain one day, you will give his judgment. It's fine. No question of going again back to court. So quick, within a month maximum, you can complete your dispute settlement in a month or so. Arbitration, that's why we have a separate act called Mediation Arbitration Act, giving legal sanctity to the decisions given by the arbitrator or mediator or conciliator, we call conciliation. So it's just like any mediator, you both have some problem. You argue, both of you decide to disagree, then better go to a third party and then tell the third party, this is our problem, you please tell who is right, I am right or he is right. We will abide by it. Because nobody can be a judge in your own call. We say one of the principles of natural justice, which you study when you come to the study of administrative law. Nemo judex in sua causa, that's a legal maxim which says that nobody shall be a judge in his own cause. Because I always think I'm right. You always think you are right. She always thinks that she is right. But both of you have a dispute like this. So the third party can independently, neutrally decide. That's why we have this system of judges. But then if the system is taking such long periods, there are many reasons. Well, number of courts are less, number of judges are less, etc. So many reasons for that. But whatever may be the reasons, the delays are delays. And so to avoid the delays, the Prime Minister has been saying that even the last citizen in this country should get justice, and they should get speedy justice. That should be the object of the Supreme Court, which is the sentinel of protecting the constitutional rights of the people of this country. So 4 clinical cases, 20 compulsory papers, 6 optional papers. They have a very big list. You can choose from the options. 20 are compulsory, you can't change, as I said, in the Indian Penal Code, Indian Contract Act, Constitution, etc. There are no option there. 20 mandatory courses, 6 optional courses. How many now? 30 law. And then 12 courses of the first degree. Whether business administration or law. 40, 2 in English. Because people from different backgrounds, from different mother tongues are coming and studying law in English. This is another unfortunate thing for all of us. I'm educated right from a childhood in my own language, my own mother tongue, but now we are compelling that we should study only in English, because all laws are enacted in English, even today. In the assembly, I am sure 90% of the MLAs do not know what they are enacting. I am sure about that. Either because most of them do not understand English, and even those who understand English, they only know the plain meaning. They do not know how it's going to be interpreted tomorrow by the courts. So laws are made by such people. Okay? Again, this comment. Okay. So 42 plus 2, 44. These are compulsory life. And then, because of the honors degree that's going to be awarded, you have to study 8 papers, either from one stream or from different streams. One stream means international law, let us say. International law, international covenants and then international trade laws, etc. So many subjects are there: international law, private international law, public international law, etc. Or from constitutional law, different constitution of America, constitution of Britain, 8 subjects from constitution. And that means option is given to you to choose either to study all the 8 papers from one stream or 2 from different streams. You can also choose 2 from international law, 2 from constitutional law, 2 from personal laws, 2 from mercantile law, commercial laws, etc. So that's left to the student at the end of your program, in the 4th and 5th year. If you are choosing only constitutional law, we will give you a BA, LLB, honors in Constitution. If you choose all 8 papers from personal law, if you choose all 8 from commercial law, you will be given BBA, LLB, honors, commercial law, or business law, whatever it is. Or if you choose in general from different streams, then it will be only general honors degree. So this is about, I think the subjects, etc. you will be more. Perhaps another department, you have to please ensure, please ensure that a copy of this is given to each student.
Okay, sir.
Because they should know what are the subjects. And similarly, you need some gap, 5 minutes gap? Water. I will again, very briefly, introduce to you the academic regulations which were drafted by me and approved by the Board of Studies in Law. The objectives of the programs, etc., and then the papers we have given here. Although it is 52 prescribed, we chose another 8 papers more. Like, for example, Introduction to information technology. I think it's already, I don't know whether it is relevant nowadays because you already have been introduced to information technology, but whatever. There may be students coming from rural areas where they might not have had the opportunity of studying these computers, what is computer, and how computers are used, etc. And then the latest developments of artificial intelligence. A day may come when human beings are not required to judge or to work as judges. All program is given everything, and then artificial intelligence, they will judge machine learning. So a day may come when the judiciary may disappear and all decisions may be rendered by program, prepare a program. If this is this, X wins. If this is this, Y wins. Who wins? Machine will tell you. Right? So, outcomes of the program itself are very thing. Duration of the programs, intake, etc. Eligibility for admissions as prescribed by the Bar Council. And details of the courses offered, coursework and attendance. 70% of attendance for each paper, in each paper, is compulsory. Those who do not put in the minimum of 70% of attendance will be detained. Please be sure about that. It's not like any other, because in Bar Council, if you don't attend 70% of period, and still if you are passed, even if you pass, if the degree is given, the degree will not be considered as valid. Many people who are working in Tamil Nadu and who are joining the law colleges in Chittoor, Tirupati, etc., they lost their degrees. Bar Council has taken up, conducted inquiry, and then the degrees were cancelled. So, minimum 70% attendance is compulsory for all of you. Then the evaluation system. Okay, help me this, please come. In most of the other departments also, in Harvard University, we have the system of 70% of marks in the external examinations. At the end of semester, you have to write an examination for 70% of the paper, of which about 15-20 marks will be for short notes, and then some essay questions, and then problems, particularly in law. We insist on problems. We give you a hypothetical problem with some facts and then ask you to decide, applying the law that you have studied in the law of contract, the law of crimes, etc. So problems, because then only you will get a better idea of reading something from a book and repeating it, keeping it in your memory is fine, it's okay, but application, the knowledge that you have acquired has to be applied to a particular fact situation. So we test your knowledge of application by giving at least 30%, 30 marks out of 70 for problem solving. So this is the 70 marks. And then there will be internal continuous assessment, we call it internal evaluation for 30 marks. In each course, 30 marks are awarded by the concerned teacher by conducting 2 tests for 10 marks each, 2 times in the semester, after first only 1 month or 1.5 months, and then before the semester end exams, 1 more test, 10 marks each, they conduct a test for you, 20, and then 5 marks are awarded to each student on the basis of some questions that the teachers put to you in the course of the lectures. So 5, and then other 5 will be for attendance. 5 marks will be given for attendance. If you attend above 90%, you will get 5 marks automatically in each subject. 90 and above percentage of attendance will fetch you 5 marks without anything further. Your attendance in the classroom itself is enough. So between 80 to 100, the ability is also given. Between 80 to 90, 4 marks. 70 to, so 3 marks. So that out of 5, the marks are given depending upon your attendance. 90 and above, you will get total 70 to 80% 1 mark. Because 70 is minimum. 80 to 85, 2 marks. 85 to 93, 91 to 95, 4, 96 and above, 5. 96 and above 5. So if you attain at least 90, you will get 91%, means 4 marks out of 5. Okay. So this has to be acquired by you. The teachers have to create interest in you about this, and then you have to, this being a professional course, all of you are expected to do that. Then, another important thing which I would like to explain to you, and also to the teachers who are going to teach you, we are going to adopt what is called a grading system. Grading system. So instead of marks, 80%, 70%, etc., we give you a what we call a grade like X, A, B, C, D, E, F. Letter grades, they are called letter grades. Those who are excellent will get X grade. And what is those excellent means? This is what again is called, we follow relative grading system. Relative. There are two different types of grading systems. Absolute grading system, perhaps you are, I don't know, you are intermediate. They have adopted this absolute grading system. Everybody who gets above 80 gets, let us say, X or A. Everybody who gets above 75 gets A. This is already given to you in the beginning itself, how many marks you are going to get. But relative grading system is not like that. It depends upon the actual marks secured by the students in a class. Sometimes some paper might be tough and you might get only 60%, the highest marks is 60%. So according to the absolute grading system, you will get only C grade. You are highest, you secure the highest marks in the subject, but still you get only C grade. But here, in a relative grading system, it's not like that. It depends, even a person who gets 56, which is highest, will get X. Because it's a relative. You are the highest person, so you should get X grade, irrespective of the number of marks secured by you. So this system works like this. For example, let us say 50 students in a class. And out of 50 students, let us say 50 into 50. Total how many? Total marks secured by all the students divided by 50, number of students. This is called average marks secured by, we will calculate the average marks secured by the students in general. Some might get, let us say, 5 students secured 80 and above. Another 5 students got 75 to 80, etc. And 5 students got below 40. And maybe the 20 students secured 50 marks or 50, 55. So now what we do, the concerned teacher, he calculates the total marks secured by all the students in the class divided by the number of students, and if that is 50, we call it average. This is the average. That is, a student who secures the average marks will get the C grade. So from this onwards we go up. So if 5 students are secured 80 and above, depending on some dips and gaps, we say that the system where most of the IITs, IIMs, etc., and even the national law schools follow this system of relative grading. So 80 and above, let us say 5 students secured 80 and above, so we award X grade for all the 5 students who secured 80 and above, and excellent means 10 out of 10. X is A grade, suppose below, some 5 students got 75 to 80, they will be given A grade. A grade means 9 out of 10. So on it goes. Excellent, A means very good, C is good, B is good, C is fair, D is satisfactory, E only pass, F fail. So below minimum 40, if you get, you will come under this category. So this depends upon, so after, this is the normal rule we follow. Average, those who secure the average marks will get C. Above average, if you get, you may get B, A, or something like that. This is how the relative grading system is conducted, and then out of, in each subject, this is awarded, this letter grade is awarded. And after, at the end of the semester, we calculate all these grades, and then each subject carries some credits, what we call credit system. All law subjects carry 4 credits, and the first degree course, the discipline of BBA or discipline of arts or whatever, it carries 3 credits, English carries 3 credits, etc. So credit system is given to you. So according to that credit system, we calculate at the end of each semester what we call CGPA, cumulative grade point average. And second semester, suppose this semester you have got 9 in all these 6 subjects put together. Then you have, suppose next semester you get improved, you improved to 10. So at the end of second semester, yours is 9.5 CGP. Again third semester, fourth semester. So at the end of each semester, we calculate the grade point average and we call it CGPA at the end of first semester or second semester at the case may be, and then final semester. And these semesters, this calculation mode also is given here. CGPA is equal to C1, G1, etc. by C1, C2, great number of credits carried on. That I don't need to go to that technical aspect. And depending upon your final award of degree, a candidate shall be eligible for the award of BA, LLB honors or LLB category if the candidate satisfies the minimum academic requirements in the course. The degree with the third class will be awarded to candidates who obtain minimum CGPA of 5 and less than 6.5. 5 is the minimum. So those who secure between 5 and 6.5 will be declared as passed in third class. The degree with second class will be awarded to candidates who are equal to or more than 6.5 and less than 7.5. First class will be awarded to those who secure equivalent to or more than 7.5 and above, up to or less than 8.5. The degree of first class with distinction will be awarded to candidates obtaining equivalent to or more than 8.5. This is the degree that you are going to get. Now briefly, these are the academic regulations which we have adopted for you for the coming 5 years. These are all adopted by the Board of Studies and then approved by the professor. The next only, we give you the program structure of all the 60 papers. In each semester, at the rate of 6 papers, you have 10 semesters, 10 into 6, 16 as I said. Although the requirement of bar council is only 52, we selected some papers like, for example, information technology, patent law, that's not there, right to patents, etc., trademarks, etc. All those courses which are not there earlier in that, we selected some of them, and then other than this law also, like for example, quantitative methods. Some subjects we have selected which are absolutely useful. For example, art students, they have sociology. But BBA doesn't have sociology, but still we said sociology because, as I told you, after all, the law functions in a society. The purpose of law is to function in a society, to regulate, just like social development, social regulation, so many. So, to avoid social conflicts, etc., etc. That is why, actually, why I said in the beginning, BA, LLB, the judges, etc., thought that the knowledge of political science, history, public administration, economics, sociology are absolutely necessary for an advocate to understand the law. Law doesn't function in a vacuum. That's why we said law functions in a society. So economic aspects of the law, sociological aspects of law, historical aspects of law, etc. have to be studied. And then law and state, as I said, political science. That is the science which teaches you about the authority, about the power, etc. How political science. So these are they thought that the knowledge of these subjects, social sciences we call them, because law also is a social science. In addition to the arts courses like political science, history, sociology, law also is a social science. But later on, they said, okay, these things can be learned by anybody, and so let us also start BSc LLB, BCom LLB, BBA LLB, etc. They said, okay. And then the Bar Council accepted it, and that is why you have now the nomenclature of BSc LLB, BBA LLB, etc. So these 60 subjects are given, and then finally we give you the syllabus of these 12 papers of the first 1 year is here. So I recommend that this whole book must be copied and given to all the students so that they will read for themselves the academic regulations and then the syllabus of that particular year, also the faculty, which are there. We divided all these into 6 units or something like that, and then you can understand. Introduction to Law and Legal System, this one paper extra we added, it's not there in that because we thought you have to be given an overall idea about law, a bird's eye view about law in the first semester itself, like as I told you, what is law, why law is required, how the various jurisprudents have explained. As I said, one person said law must be understood from nature, from God. Another said must understand from sociological perspective, historical perspective, economic perspective. And finally another fellow said, why all these other social science perspectives? Let us understand law from terms of law itself. That is what he called pure theory of law. Pure theory. The other theories are not pure because they have become pure because of the importation of other social sciences. Studying law from historical point of view, studying law from sociological point of view, from society point of view, economic point of view, morals point of view, etc. Why you do that? Law you can study by itself. You don't study or bring other disciplines. We need not study law from the point of view of other disciplines. We can study law from law. Law consists of norms. First primary norm, secondary norms, and then grand norm, etc. etc. Professor Kelson, one person. Pure theory. So, general idea you get, and then the classifications of law, and then something about the legal concepts, because in every law book you find these terms like right, duty, ownership, liability, negligence, etc., etc., intention, recklessness, negligence, and some of these concepts, person, etc., these concepts, so you should understand, at least at the beginning, the meaning of these terms, and although you study in detail, the same thing, again, when you come to jurisprudence. Juris means law. Prudence means knowledge. So jurisprudence, which you are going to study, it's also called legal theory. So theory. Various theories have been propounded by various scholars at different times from different points of view. And those theories, not in detail, at least, so that you can also give your own meaning to the word law, because there is not law is not defined anywhere in any statute. So that's what we understand by legal system again, how the law functions in a legal system, how the laws are made by various legislatures, and also how the legislatures delegate some of their powers to the executive, delegated legislature, etc. How they are implemented, the executive body at the center as well as at the states, and then the judicial system. All this you will understand if you understand the legal system. So this is the gist of what I wanted to bring to your notice. In the beginning itself, actually, I thought of coming to you before Pongal, before January 12th or so. Then you heard the department said, sir, suddenly our hospitals are closed and so they're gone. And then she said, okay, we'll fix some other date so that we give them some introduction as to what we are going to study in these course for the coming 5 years. Okay, then now, your turn now to put some questions. If you have any doubts, etc., you can clarify your doubts by asking me. Any questions about your 5-year program? Nothing? How many of you are from Guntur district?
Yes, madam.
Please raise your hand. 1, 2, 3, no, not teachers, students. 3, 4. How many are from Vijayawada district, Krishna district, or what is that district? I don't know. Krishna, NTR district. Yes. Only 1, 2, 3, 4, 5. Krishna district. Good. And what are the other districts you belong to? Rayalaseema?
Total Rayalaseema, I think.
5. North Andhra, Visakhapatnam, Vijayanagaram, etc. I may, if the teachers of law request me to come once in a way to explain to you about this, something like, because the introduction of law and legal system was the subject which was actually invented by me. There is no other place it is there. So I thought of giving in the very beginning itself a very general view, not detailed but very general view, so that in the course of time it becomes very difficult, very easy for you to understand jurisprudence and regulations, statutes, etc. So introduction to law and legal system was the paper, which is now being taught to you by Gauri Madam. Okay.
So, you described about the credit system. So, if we accumulate a certain amount of credits, so can we be exempted from taking
No.
other courses?
No. Yeah, your question is correct, but generally what we say, when there is a credit system, they say, now let us say we have for all the together some 230 credits we have prescribed. At the rate of 4 credits for a law subject and 3 credits for other first degree subjects, etc. 230 credits. Nothing is optional, everything is compulsory. You have to study all the 230 credits. And the actual importance of the credits is, number 1, if there are 4 credits for a subject, there will be 4 periods in a week for that. If there are 3 credits, there will be 3 periods in a week for that subject. That's one. And second, while calculating the CGP or GP, that 4 also counts, because if a subject of 4 into 10, 3 into 10, suppose these 2 subjects, we call it 4 into 10 by 6.5 or something like that average. So at the time of calculation of the GPA also, the credit is taken into account. The credit system functions. That's why we call it credits, but in most of the universities in America, etc., suppose we fix up 230 credits, whoever gets at least 200 credits will get a degree. That option will be there, but here we don't have such option. You have to necessarily complete all the 230 credits. Only thing is, as I said, you will be given an option in the final 2 years or final 4 semesters to choose papers from different streams or different specializations, what you call it. And either you select 2 from each stream or all 8 from one stream, etc. You can do that, but that's only after 3 years. So we need not bother about that now. I can take leave. Thank you.
Here from the Rangaiah BOS senior faculty member and also the retired professor. And, whatever he talked regarding the law subjects and also the scenario which is going to be adopted for the purpose of offering grades to you people is very much understandable to all. So versatile, previous in all subjects. Even we are teaching law subjects for last 20 years. We learned a lot from the lecture given by Rangaiah. This is the first class which I present while he is teaching. Very much impressive and caliber, capacity, intellectuality. So I'm very much grateful and thankful on behalf of BBA, LLB and also BA, LLB honors students. Thank you very much, sir.
Thank you.
Thank you, sir.